rises. Document Tingz, bringing truth to the light. Paper trail strong, yeah, we reading it right. From the docket to the drop, every case, every scene. I'm your courtroom reporter with the facts in between, yeah. Document Tingz, bringing truth to the light. Paper trail strong, yeah, we reading it right. From the docket to the drop, every case, every scene. I'm your courtroom reporter with the facts in between, yeah.
All right. Welcome back. We are here to get into some court updates now. This is just a continuance conversation from the prior two videos that I just uploaded. This is regarding Demoree Hadley versus Desiree Perez. Daughter and mother duking it out in court. Now, I've already covered and went over the Medical Malpractice Act and also the RICO claim. So we're just continuing on with our conversation. I'm making separate videos. That way you don't have to sit through each claim. If you want to get to a particular claim, then here, click on this video. This will show you this claim and you can read along. Or as I always post, look at the top left-hand corner of your screen. That is my QR code that will take you directly to my X, formerly known as Twitter page. And you can divulge in a plethora of other court documents as well. And you can get the discussion popping like many other people do. Now, before we actually get started, let me make sure y'all see my copyright disclaimer under section 107, scrolling at the bottom of your screen. It's simply saying that, hey, this is fair use. I am not a paralegal. I am not an attorney, and I am also not a judge. I am simply just saying that, hey, I got common sense and I know how to read. So without further ado, let's get into counts 2 and 3, which is the civil conspiracy. Now we're on page 20. Okay, I'm gonna scroll up just a little bit. I've already covered the RICO claim, and I have already covered the Medical Malpractice Act. Okay, so I'm on page 20. It is a total of 52 pages to this particular court document here. So we're just going to go ahead and get the discussion popping on this next count 2 and 3 civil conspiracy. Okay. All right. So have a seat, grab your drinks, grab your snacks, and let's get into this read. Okay. All right. So under Florida law, a claim or a civil conspiracy requires 1, an agreement between 2 or more parties. 2, to do an unlawful act or to do a lawful act by unlawful means. 3, the doing of some overt act in pursuance of the conspiracy. And 4, damage to plaintiff as a result of the acts done under the conspiracy. Parties are acting in concert when they act in accordance with an agreement to cooperate in a particular line of conduct or to accomplish a particular result. And it says this, the agreement need not be expressed in words and may be implied and understood to exist from the conduct itself. Okay, so let's get into count 2. Civil conspiracy against Perez, ROC Nation, and Anderson argue that plaintiff's civil conspiracy claim is barred by the intra-corporate conspiracy doctrine. Plaintiff responds that the personal stake exception applies because Perez, Anderson, and ROC Nation were not acting within the scope of their employment when they conspired. The intra-corporate doctrine states that a corporation cannot conspire with its employees and its employees when acting in the scope of their employment cannot conspire amongst themselves because a corporation and its employees are considered to be a single legal factor. The reasoning behind the intra-corporate conspiracy doctrine is that it is not possible for a single legal entity consisting of the corporation and its agents to conspire within itself, just as it is not possible for an individual person to conspire with himself. Nevertheless, under the personal stake exception, where an agent has a personal stake in the activity separate from the principal's the principal interest, the agent can be liable for civil conspiracy. That's just a quote, y'all. A personal stake must be more than personal animosity on the part of the employee. The employee must have acted in their personal interests, wholly and separately from the corporation. It says internal quotation marks omitted. Where plaintiff contends that while the amended complaint alleges that Perez and Anderson were employees of ROC Nation, it does not allege that Perez and Anderson were acting in the scope of their employment, and thus the intra-corporate doctrine does not apply. However, even drawing all inferences in favor of plaintiff, the amended complaint fails to allege that Perez and Anderson acted in their personal capacities. The amended complaint asserts that Perez directed Natalie Anderson, a ROC Nation employee, to confront plaintiff's therapist. Perez wanted to Dr. Bureau to believe that plaintiff had some type of mental health issue to capitalize on her threat to Baker Act plaintiff. In that Perez and Anderson, both employees of ROC Nation, entered into an agreement to achieve the common goal of trying to convince a healthcare provider to commit plaintiff to a mental health facility. The amended complaint also pleads in the alternative that Perez and Anderson, both employees of ROC Nation, entered into an agreement to achieve the common goal of trying to cause intentional infliction of emotional distress upon plaintiff. Most significant, the amended complaint asserts that Anderson was acting in her capacity as Perez's assistant at ROC Nation when the incident occurred. There was no allegation that Perez, Anderson, and ROC Nation acted in a personal capacity apart from their employee status. A corporation cannot conspire with its own directors, officers, or employees. Plaintiffs' respective responses to the motion seemingly attempt to add in new facts to explain how Perez and Anderson were not acting in their official capacities. Anderson may have been working for plaintiff when she visited Dr. Barrow's office, but that was not within the scope of her authority, i.e., she was not implementing the corporation's managerial policy. It says Anderson's job description did not permit her to behave in such a fashion. Anderson may have been working for Perez when she went to Dr. Barrow's office, but that was not within her authority, meaning she was not executing the corporation's managerial policy. Such conclusory allegations are not only impermissible, but also impersuasive. On a motion to dismiss, the court is bound by the four corners of the complaint, which here allege that Perez and Anderson are acting as employees of ROC Nation. Therefore, plaintiff's conspiracy claim is barred by the intra-corporate doctrine. As ROC Nation points out, it raised this exact argument in its initial motion to dismiss. A district court may dismiss a case with prejudice after a plaintiff has been afforded the opportunity to amend their initial complaint. And that's just a cite, as y'all can see there, from another court case. Okay, so count 3, which is Perez, Signan, Fondue, Stephen and Jessica Caddy, and Barbara. Conspiracy is not a separate or independent tort, but is a vehicle for imputing the torturous acts of one co-conspirator to another to establish joint and several liability. There is no freestanding cause of action in Florida for civil conspiracy. In order to state a claim for civil conspiracy, a plaintiff must allege an underlying independent tort. Further, general allegations of conspiracy are inadequate. A complaint must set forth clear, positive, and specific allegations of civil conspiracy. Here, Perez, Signan, Fondue, Stephen, and Jessica Caddy, and Barbara all argued that count 3 should be dismissed because plaintiff fails to allege an underlying tort. Further, defendants assert that the amended complaint fails to allege that they were working in concert and merely reflects parallel independent conduct. Plaintiff responds that counts, and then y'all can see right there, 4, 5, 6, 7, 8, and 9, or 10. I think that, well, what is it? 4, 5, 6, 7, 8, and 10. Well, 9, however you say that shit. Lord have mercy. However you say that, form the basis for her conspiracy claim. Further, plaintiff contends that the court, oh, that's 5, 5, 6, 7, 8, 9, 10. Okay, sorry. Let me continue. Further, plaintiff contends that the court may consider circumstantial evidence to find that a conspiracy exists and that she has adequately alleged a conspiracy. At the outset, the court finds that plaintiff identifies the underlying tort and incorporates the same in count 3, alleging that the parties entered into a conspiracy to falsely imprison plaintiff. Further, for the reasons set forth below, the court finds that the amended complaint adequately alleges the underlying claim for false imprisonment against Perez and Sig9 and a conspiracy. Accordingly, the motions are denied as to count 3. All right, so that is that. All right, so the next video that I upload will be about the counts that y'all see here. Fourth Amendment violation. We will get into that. And then we'll get into count 4. Well, actually, let me do this right now because as y'all see, well, no. That will be a separate video. All right, so we're gonna end right here, and then we're gonna make another video about the Fourth Amendment violation. If you like what you see here today, like, share, subscribe. As I always say, when you lead with integrity, you never have to worry about somebody questioning your loyalty or your intentions. And with that being said, talk to y'all soon.